All right, welcome back. The court is now on the record again in the matter of Rodney versus Mary Boyd, file number 25-14936DO. You are Rodney Boyd, correct?
That is correct, Your Honor.
And you are Mary Boyd, correct?
Yes, Your Honor.
So we're here because I had issued an order, as the parties are well aware, following our last hearing. And that order required that if you wanted to have a default set aside, Ms. Boyd, you had to file that motion, and you had to do so in accordance with the court rules. And Mr. Boyd, though, before I go through that analysis and the background, is it your desire to still have a divorce judgment get entered ultimately?
Yes, Your Honor.
All right, and so the court notes several different things. Number one, Ms. Boyd, the law is clear in its requirements, and I tried to explain those requirements to you. I cited to you the court rule that applies. And the court rule is MCR 2.603, and specifically what that requires if you seek to set aside a default judgment or a default itself first, is that you have to file what's called an affidavit of facts, and that has to show first good cause, and secondarily it has to show a meritorious defense. Those are equal but separate requirements under the law. They also have to be filed in a manner provided as in the court rule 1.109D3, and that means either by oath or affirmation or by a declaration under the penalty of perjury. And the reasoning for it doesn't necessarily matter, but that's the requirement under the court rule. 1, good cause, 2, meritorious defense, and then both have to be under oath or affirmation or declaration under penalty of perjury. Again, at the last hearing, I went through those things with you. I explained to you that if those were met, I could and would have this discretion to set aside a default. If they were not met, they are not met. And in that circumstance, I would not have any discretion. The court would further note that in your letter and in your motion, you attached a letter. What you indicate to me is that you had a complete misunderstanding that Mr. Boyd was going to proceed with this divorce. The court would note that perhaps that would meet the good cause requirement. Good cause is a valid or good reason why you didn't file any answer to the divorce complaint. But independent of a good cause finding, even if one was offered, I would have to find, if you wanted me to set aside a default, I would have to find that there is an affidavit of fact showing a meritorious defense that's verified in the manner prescribed, as I've already indicated. Within your one-page attachment, nothing that you've offered suggests any meritorious defense. For example, nothing that you've offered tells me why you would suggest something different than Mr. Boyd would, or why anything that he's proposed is inequitable, unfair, or otherwise unconscionable. The meritorious defense part of the analysis under 2.603 is completely lacking. And I even indicated to you, Ms. Boyd, that if you had questions about how to proceed or didn't know how to proceed, you should hire an attorney. Because as I explained to you, the legals are legal requirements. They're not simply something that are requested by the court. I have to have them if I'm going to set aside a default. In this case, again, even if I accept your statements that you did not think Mr. Boyd was going to go forward, he said that he was ready to go forward last month, and I told you I have to go forward unless and until the divorce default judgment, or default rather, is set aside. Here, I'm legally without the authority to set aside the default, Ms. Boyd, because you've not offered, according to the court rules, what is required. So your motion to set aside the default, not because I want to, but because legally I have to, is denied. That leaves us then with a proposed judgment of divorce. And Ms. Boyd, I recognize I have significant discretion in this regard. One of the things that I could do, as I explained to you before, is I could simply not hear from you. That's not the discretion that I intend to proceed with today. Instead, what I'm going to do is take testimony from Mr. Boyd, ask him what he is requesting, and then I will likely hear from you. But I do have the discretion to dispense with any oral argument or to stop you from being heard if I find that it's getting too combative or it's been not being respectful or other things. In other words, my duty is still to issue a fair and equitable judgment between the two of you, even if one is going to be issued when you don't want it to be issued. So first, Mr. Boyd, do you have any questions regarding the order so far?
No, Your Honor.
Do you have any questions regarding the order so far, Ms. Boyd?
No, Your Honor.
Some testimony from you, Mr. Boyd, to see if we can get a judgment issued. Ordinarily, I would not accept a judgment unless it was fully filled out. Given these circumstances, though, what I'm going to do is find out if it's possible to get a judgment entered. If it's not, I won't enter one. And if it's not, then ultimately I'll leave it to you, Mr. Boyd, to prepare a conforming judgment. And if you have prepared it later, then I may be able to enter it. So, Mr. Boyd, please raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
Mr. Boyd, Filed this complaint for divorce, had you been residing in the state of Michigan for at least 180 days?
Yes, I have, sir.
Had you been residing in the county of Kalkaska for at least 10 days?
Yes, I have, Your Honor.
In your divorce complaint, you stated that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remains no reasonable likelihood the marriage could be preserved. Was that true when you filed the complaint?
Yes, it is, Your Honor.
Is that
Yes,
still
sir.
true today?
Yes.
And is that still true today?
Yes, sir.
Is it true that, as you stated in your complaint, that you did not have any minor children that you have with Miss Boyd?
That is correct, Your Honor.
And to the best of your knowledge, Miss Boyd is not currently pregnant, correct?
That is correct, Your Honor.
That's a statutory question I have to ask of you, so I need to put you under oath. Please raise your right hand. Miss Boyd, do you solemnly swear or affirm that the testimony you're about to provide is the whole truth and nothing but the truth?
Yes, I do.
Miss Boyd, you are not currently pregnant. Is that true?
That's true.
Given, I know that you are objecting to this divorce being going forward, but as I explained last month, this is a no-fault divorce judgment state, which means if there is a testimony that satisfies the court that there's been a breakdown at the request of one party, then I'm statutorily authorized to authorize a divorce judgment even over your objection. Understanding that, if I choose to grant this judgment of divorce, do you want your last name to remain Boyd, or do you want there to be a different last name, a prior married name, for example, or prior maiden name?
I'll change it. Mr. Boyd requested I change it, so I'll change it.
Well, that's fine, and I don't mind if you want to acquiesce to his request, but the choice is yours. If you wanted to keep the last name Boyd, you can. If you want to change it to a prior name, you can.
I'll keep it.
You'll keep the last name Boyd?
Yep. Yes.
And Mr. Boyd, to the extent you wanted to weigh in, I would simply indicate that when there's a dissolving of a marriage and a divorce, it's ultimately up to the wife to determine whether or not she keeps the name under the marriage or she returns to a different name. That's the wife's choice, not the husband's. Mr. Boyd, have you ever made a request for spousal support?
No, Your Honor.
You understand that if you have not made one by this point, you never can make one again, and I will issue an order that bars spousal support for you and for Ms. Boyd, and that will remain in full force and effect. It cannot be changed by later court order. Do you understand that?
I do, Your Honor.
Under beneficiary and pension rights, there are two different options under this divorce judgment. One is I could provide beneficiary and pension rights elsewhere in the judgment, or two, I could extinguish them. If I extinguish them, it means that to the extent you had beneficiary rights relating to Miss Boyd, or she had them relating to you, or to the extent you had rights to her pension or she had rights to your pension that could have arisen during the marriage, they would be extinguished. Do you have a suggestion on which box I should check?
No, I would like them extinguished, Your Honor.
In terms of personal property, Mr. Boyd, do you believe that you have the personal property that you're entitled to from the marriage?
Yes, I have the personal property that I had going into the marriage.
And do you believe that Miss Boyd has the personal property that she's entitled to from the marriage?
Yes, she has personal property that's in her name.
And do you understand that if I grant a provision that says each party is awarded their personal property in their possession, that's what it means? You have what you're entitled to if it's in your possession. And the court won't entertain any motions regarding personal property after this date.
Yes, I do understand, Your Honor.
Do the parties own real estate?
I have a mortgage on my residence, Your Honor, in my name, and Miss Boyd owns her residence in her name. That's the only real estate.
Is that accurate, Miss Boyd?
Yes, sir. Yes, Your Honor.
So, Mr. Boyd, is your request that you retain your real property and that she retains her real property?
Yes, Your Honor.
Miss Boyd, do you have an objection to that?
No, Your Honor.
So I'm going to hand right in, two things. One, I've checked the box indicating that real estate is provided elsewhere in the judgment, and the elsewhere is in page 2. And what I'm writing in is each party is to be awarded real property, which is titled to them. Is that your agreement, Mr. Boyd?
Yes, Your Honor.
Is that your agreement, Miss Boyd?
Yes, Your Honor.
Regarding anything that I've said so far, did you have an opposition to any of those things?
No, Your Honor.
Is any of the proposed, let me ask it this way, Mr. Boyd, do you agree that the way that we've gone through this judgment and the way that you're going to get things under the judgment, do you think that's a fair way to dissolve the marriage and your assets?
Yes, Your Honor.
Miss Boyd, do you have any opposition to that finding?
I do, Your Honor.
What is your opposition?
I'm not asking for like monetary or like I'm not looking for his house. But I came into the marriage with a vehicle and Mr. Boyd hit a deer with my vehicle and I have no transportation. Mr. Boyd said I didn't have to work this whole time because taking care of the house and what I did at home was adequate. Now I have absolutely no savings. I have no money. I have no place. I have a tenant in my place right now, so I don't even have enough money to get into a place. I have 2 dogs. We have 4 dogs. I have to find a place with dogs. And I have absolutely nothing. I can't even leave the house right now to even try to find another place because I have no vehicle, but the vehicle was covered under our vehicle insurance, and I've been a year without a vehicle. The only
What is your
vehicle
request?
I need to get some sort of vehicle and have some kind of way to be able to support myself, as Mr. Boyd's been the only support for me. I get $1,000 a month for rent, but I have property taxes and a homeowner's insurance, and
What specifically is your request, Ms. Boyd?
I'm gonna need a vehicle and some kind of like monetary money to be able to leave the house, to be able to get into another place. I'm not asking, I need a vehicle and like enough money to live for a few months at least, because I don't have a job or any money. So I'm like,
To be heard regarding Ms. Boyd's complaint or request?
Pardon me, Your Honor, you broke up.
Did you wish to be heard regarding Ms. Boyd's request?
Yes, Your Honor.
Go ahead.
The vehicle, I offered to get her another vehicle, and she kept denying me to get her another vehicle. Regarding employment, she was never told not to get a job anywhere. I even encouraged her, but there was places that she didn't want to work certain days, and she didn't want to work on weekends for that. So that is not true.
Offered to provide a vehicle to her?
Yes, I did.
What vehicle?
I wanted her to go with me to find a vehicle for her.
Do you know what vehicle or what amount of money you would be willing to spend?
I get from the insurance, I received $5,000 back. That doesn't cover what I paid into the vehicle naturally, but that's what I was looking for to get her a vehicle with, was $5,000.
So it sounds like what you're saying is you would be willing to utilize that $5,000 towards a vehicle for Ms. Boyd. Is that right?
I would, Your Honor. I am not working either right now. I have no medical in that, but I would come up with that to help her get a vehicle.
How long would you need to just pay her that money so that she could make a decision on a vehicle or whatever other expenses she wanted to have? How long do you think it would take you to pay that amount?
I could get it together by tomorrow for her.
Ms. Boyd, does that adequately address your concerns?
that addresses my concern about getting a vehicle. I mean, he did offer, but we were married and it was winter and I didn't go out. He's sick and I offered to not have a vehicle for him to be able to get health insurance. I didn't turn him down for any other reason than it was we could only afford one or the other. But I mean, I would take the $5,000 to get a vehicle, but I still don't have any place to go. Like I said, we have a tenant at my house in town. She's a school teacher leaving Michigan in June. I have no other residence to go to. I don't know where I'm supposed to go with no other money. I'll have a vehicle and I can go get a job. And I was told that I didn't need a job. So, but I still will need some kind of support to be able to get into a place. My son is in jail.
The court would note that I understand you have a lot of concerns, but those concerns really don't answer the question before the court, which is you asked for some assistance. Mr. Boyd had no obligation to make an offer of that, but he did make the offer of it. I'm going to take him up at that offer. But I would note again and remind you that several things are important in this context. Number one, as you stated, even through your own language, you have been threatened with divorce many, many times over the past. My presumption in that regard is you understand that when and if there is a divorce, things that have been happening in the past do not continue to happen the same way in the future. You have also made clear, based upon your statements here on the open court record, that you have a residence and that you have a renter and that you have income currently and that you're unemployed, but that you can get employed. You also have made statements such as you don't have money to do things. And if that's the case, you have a residence and you have the ability to either move in with that renter or seek to evict that renter if you have the lawful authority to do it. But there is always change with every divorce, and I understand and recognize that. But that does not undo otherwise what my role in this case is to do. I have to recognize that there's a default in place. I have to recognize that the motion to set aside the default is not properly filed by you. I can't grant it. And I have to recognize that Mr. Boyd also has competing rights in this case. One of those rights is, if he files a proper complaint for divorce, to have the divorce judgment get entered. Again, he had no responsibility to offer to pay that amount to you, but I accept his offer. And I find it to be fair and equitable given the circumstances, and it counterbalances any claim by you that you need more. So I am going to require that plaintiff shall pay to defendant the amount of $5,000 for purpose of purchasing as a vehicle. And that will be in the next 14 days that plaintiff is required to turn that over to you. On balance, and based upon what I've heard, and specifically because each one of you has your own items of real property and your own items of personal property, I find that to be fair and equitable given the circumstances, even though if there were not a default in place, you might have been able to convince me otherwise. A default is in place, and again, my duties according to law are to get this case to move forward towards the entry of a judgment at the request of Mr. Boyd. So the court does find that the statutory grounds for the issuance of a judgment of divorce have been met. I accept the other testimony that's been offered today. And in sum total, given the circumstances and despite the objections by Ms. Boyd, I find that the judgment is in totality with those two added provisions by the court combined to make a fair and equitable judgment for this default judgment of divorce, and I will enter it. I will sign it on today's date. Then it will be handed to the clerk for filing, and once it's filed, that will be final, and the matter will be resolved. Mr. Boyd, do you have any questions?
No, Your Honor.
Ms. Boyd, do you have any questions?
Nope, I don't.
The court then will be in recess, and I appreciate that each one of you was here and advocated for your positions.
Thank you, Your Honor.
Default divorce hearings like this show how critical procedure can be. In family court, missing a deadline or failing to file the right affidavit can completely change the outcome, no matter how emotional or compelling the situation feels. Judges are bound by court rules, and without a verified defense, their discretion is limited. This case is a reminder that understanding the legal requirements is just as important as telling your side of the story. We'll continue breaking down real courtroom decisions and what they mean. If you want more in-depth family court updates, make sure to subscribe so you don't miss the next case.